All right. Good morning, Chair Postman, board members, Garrett, Hauge, staff, and attendees. Lobby is open. Recording has begun.
Great. Thank you, Dustin. With that, we'll call to order the board caucus meeting for Tuesday, September 28th, 2021. I'm David Postman, the board chair, joined by members Russ Hauge and Ollie Garrett. And our first item on the agenda today is approval of the minutes of the August 31st, 2021 board caucus minutes. Motion to approve?
I will move approval.
Great, and I will second, and that is approved. And then the next is approval of the September 14th, 2021 board caucus minutes.
This is Ollie. I move approval of the September 14th board caucus minutes meeting.
Great, and I will second that, and that also is approved. We're now going to hear from Justin Nordhorn, our Policy and External Affairs Director. He's going to brief us on the proposed federal legislation on cannabis. This was something that member Hauge raised a couple of weeks ago about just our real need to dig into that and start looking at how the agency is going to respond to that. We can talk later about what we think the odds are of anything happening really quickly, but the first step of that has been that Justin has taken a deep dive into the draft bill, worked with people throughout the agency to hear concerns. Excuse me, we've also been talking with some of our friends around the country. So with that, I will turn it over to you, Justin, to take us through this.
All right, well, good morning, Chair Postman and members of the board. We're going to just kind of walk through this at a fairly high level. There's obviously a lot going on with the federal discussion draft. And we've had a number of conversations, like you said, internally. And what we tried to do is break apart the 160 plus page bill into different sections, for example, around public safety, taxation, those types of things, and provide input. And how would this kind of impact the state of Washington as it stands right now? We don't expect the federal language to stay stagnant through the process, so I'm sure there's going to be a lot of iterations as it develops over time. We've also had some good conversations nationally with other states and also through our national organization. And so it's really a culmination of all of those types of identifiers together. And so as we walk through this, this is, it's really critical for the federal standards to set that foundation and platform. And that's one of our messages that we want to make sure that there is out there. Because if we don't have that consistency on the legal products, especially when it opens up to interstate commerce, we can have a number of issues going on. And so, for example, if we don't have standardized lab testing across the United States on what does that look like, you could end up having people wanting to get their lab testing done in other states and then bring product back in. And how are states going to manage and mitigate risks associated with that? And then, of course, online sales conflicts are going to be prevalent if packaging and labeling is drastically different in a number of areas across the state. And so when the federal structure sets up with the FDA and then the other agencies such as the Tax and Trade Bureau or Trade and Tax Bureau, that we end up having some good foundational pieces for the states to be able to rely on that national consistency. There's a lot built into the discussion draft around states' rights and making sure that the states have the opportunity to regulate and govern the products that are being grown in their state and sold in their state. And so, we tried to look at that in that particular lens as well. So, general positives, of course, looking at national legalization would open up banking opportunities for all, which really can change the dynamics across the United States. Although taxation was raised in the bill, not a lot around the banking issue, but it will definitely be a positive to open that aspect up. We also see some positives potentially, even though that there's some tax implications in the bill, that I thought should be important to call out is the opportunity for licensees to operate under normal business circumstances as other businesses. So, for example, being able to take the tax credits on net income versus their gross income, being able to utilize the 280E tax exemptions and those types of things. So there's some positives in those particular areas. And like alcohol, there's provisions in the draft that really create thresholds for smaller businesses. So for Washington in particular, I think this would be a positive for Washington licensees because we already have a predominantly small business environment. I don't think any of our licensees really would fall into the big business category. And so there could be some benefits there for Washington businesses as well. A couple of the key overall points of analysis that we wanted to look at. Again, what we're trying to look at is, well, first, let me also call out that part of this work that we're doing around the analysis is what type of response should we have to our congressional membership and those types of things. And so we're looking at those opportunities, and this is part of that step is, seeing what's of interest to call out. And so we kind of threw a whole bunch of things in here. And, I don't know if we want to be as broad or we want to focus on a couple areas, but, kind of putting that context there as why are we looking at this when it's not, actually a bill before Congress yet. So we definitely want to be able to provide some feedback and create awareness of how this will impact our state as well as, the national endeavors on interstate commerce. So as we look at the federal regulations, we really want them to create some sort of a floor on regulation standards that everybody can adhere to, and not necessarily a ceiling. Don't put the caps on different things because states already have a number of programs that could then be negatively impacted through that. And we'll call out a couple of those points. So that's really one of the themes that we want to be looking at. And we also want to be able to be responsive to urgent regulatory needs, both public health and safety, as well as markets in the state. And so if we have too strict a regulation, we're going to be kind of tied to the federal response, which typically, I think everybody would agree, takes a little longer than the state responses are, when we're looking at rule making and deeming and those types of things. So it's just, the processes that we've seen over the years, and I'm not trying to say, right, wrong, or indifferent, but we do see some lag time in those. And I think that needs to be considered as we're going through this. So we've got a very dynamic marketplace. We have products are evolving rapidly. And so we need to be able to keep pace with those emerging products. And we certainly want that ability as we move forward. The minimum standards that are needed for lab testing are important, especially around ingredients and additives, packaging and labeling and the like. So those regulations are going to be important for us to be able to monitor and look at it. And in the absence of that, all the different states are going to develop their own standards. And so that could create some variances in testing methodologies and threshold for cannabis testing and those types of things. And so how are states going to be able to contend with that? So, when the states are creating their own approach for review and evaluation of the safety of new product and additives, and we're developing our approaches to the packaging and labeling, we're going to have different information, spreading across the United States around, potential harms and those types of issues that may be in the products. And then you end up having debate between states on, well, this state does it this way, which way is the right way scientifically. And so really the federal government should have that floor set forward so everybody can rely on that. The challenging issues, around this could really include regulating the structure and function claims. We're already seeing that. We're already doing some work in our state around, how does that look on the packaging? It's traditionally been an FDA type of an oversight. So that can certainly be a challenge, especially if they're going to treat cannabis like dietary supplements. And then also language that would be indicating whether, the claims are truthful or misleading. And so those are pretty challenging aspects to be able to look at. So the federal minimum standards and clarity, would really be needed to support, state regulation around these particular areas. So I think we also want to look at the issues around clarifying between hemp regulation and cannabis regulation, and that's really, in our opinion, urgently needed. And we have, state laws around the two. We have federal laws for the Farm Bill, and we really need to have that clarity, especially as we're seeing emerging products. And we need to be able to establish regulation of impairing cannabinoids that are other than the Delta-9 THC. And so, how do you regulate that, and is that going to be called out? We have a number of related items that are being derived out of hemp, and they're online and they're in the marketplace with little to no regulation at this point in time. So in some states, we have, hemp products can legally contain more THC than products on the state regulated marketplace, and also they're not subject to the same testing and safety protocol standards. So that's really a concern when we're looking at some of the consumer safety issues for products being sold within the state. The federal structure for regulation needs really clearly include product types such as Delta-8 and Delta-10 in addition to the Delta-9, because in absence of that, right now we're kind of focused so heavily on the Delta-9 issues that this is really creating that uncertainty around these particular products. So the discussion draft, kind of seems to point out that the approach is general to cannabis products, and that any THC measurable, as they're calling it within the draft, any quote unquote THC measurable cannabis product, is observed in the taxation sections, but it's also called out in some of the tax drawback areas. And that calls out some specifics around Delta-9 tetrahydrocannabinol concentration. So when we're looking at it, calling it out in one part of the federal draft is Delta-9, kind of similar to what we have in our state right now. We have some that relates to Delta-9, others that just say THC. That disconnect is going to be challenging. And I think we would ask them to try to bring those in line, how you're going to treat THC in a general capacity versus calling out just one cannabinoid structure in that area. So that'll really address new products and how they're going to approach the taxation around those particular issues. The next area that I would cover, from this kind of general overview is the possible medical cannabis impacts for our state in particular. So the previous areas that I talked about, 1, 2, and 3, really do have to do with a national perspective as well as impacts on states. The next sections here I'm going to talk about kind of drill down to more of our state impacts that we would anticipate in this area. And as we're looking at the medical cannabis impacts for our state, it indicates right now in the draft that the secretary meeting at the federal level are going to consider whether unique standards for cannabis specified for medical use under state laws are necessary or appropriate. And so we have some questions around what would that mean for our particular program as DOH is looking at those oversight issues, and are we going to have somebody come in and say, no, that's not appropriate once we already have an established marketplace and structure for these types of products? So we believe that would kind of create some uncertainty for the states and as well as patients if the federal government has direction if they have discretion from the state from state to state to choose whether or not we're going to address medical programs and allowances. So if it's a pick and choose type of thing, it's not going to be very consistent, we think. And it also ties in further with the section that addresses misbranded cannabis products, as language in this particular area, calls out if it's intended for consumption or application to an individual under 21 years of age. And in general, we probably wouldn't have a lot of concerns around that, but we do have provisions that call out underage medical cannabis use. So if you're under the age of 21, there are provisions in our state that afford those patients the opportunity to get cannabis for their medical purposes. And we're kind of concerned that if we have such tight controls in the federal bill, does that eliminate those opportunities on the state level for patients? So we do see that as an impact in that particular area. The other area that we look at is defining the producer, defines producer for the purposes of cannabis enterprises, and provides an exception for personal or family use. And what that challenge in that particular area is the exception focuses on the individual, as well as, in a sole capacity, if you will. And this is going to conflict with our medical marijuana provisions in 6951A, which really allows for the medical cooperatives. And so we have cooperatives that we've permitted. And if it basically says that these growing opportunities are for individuals only, what does that do around the medical patient cooperative approach that we have in our state? Does that eliminate that? And so I think that there needs to be some consideration as we're looking at patient capacity to grow for themselves. Do they need somebody else to be growing and helping out with them? And so limiting it to the individual could really change the landscape in Washington State if it's not considered federally. Another area that we see having some potential impacts in our state, the way that the draft discussion has been laid out, is around social equity. And the definitions may create some significant differences from state to state, which could create some challenges. So we believe that the automatic expungement ideas under the social equity kind of components of the draft discussion is a real positive idea, but they do have some expungement exceptions called out, and that could have some variable implications and impacts due to the original approaches around what the federal government considers aggravating role adjustments. And so when we're looking at those types of things, that can create an underlying concern of continued inequity as we're approaching this. So if they get to adopt those aggravating role adjustments and they're being applied in different states, I mean, we already see sometimes in the federal districts different approaches to different things. How does that impact our social equity program that's being stood up? And if we take recommendations out of the social equity task force and apply them, are they then basically altered in the future based on the federal language that's drafted? And that's what the primary concern is in this area. So for our state, the social equity program implications, it may have different definitions on what an applicant would look like. So that could really set us back if it's different than ours. And I'm not saying it would be different, but as it develops, it could be different, and that could be an impact. And a possible point of contention would be the definition of the social equity applicant versus recommendations from our task force. So if the federal definitions differ from the state definitions, essentially. The criminal penalties identified in the discussion draft may continue to perpetuate barriers for social equity applicants, again, as the enforcement approaches across the United States could be different, as well as the prioritization in the federal enforcement approach. So you could still be seeing some different applications across the board. And that kind of comes into the disqualifying offense area in the federal permitting. And what the concern is if we have an applicant that we've issued a license to, then that is required to get a federal permit under the discussion draft. And now they don't qualify because they have what would be considered a disqualifying offense that we didn't consider disqualifying. Are they then, no longer eligible in the state to operate? And that really is a point of concern when we're looking at, getting the social equity off to a positive start and then having to step back because of the federal language that may or may not be developed. So, just calling out some of those issues that we found kind of concerning as a potential impact and could cause some setbacks for us. The other kind of smaller areas that the bill doesn't really call out but did catch our attention have to do with employment and contracting. So they do call out that although cannabis will be descheduled, that continued drug testing allowances can still be in effect at the federal level. Not necessarily the state level would adopt those, but then if we're have contracted federal workers, or if we're contracting with or under state or state to federal contracting. So, I'm not explaining this as well as I could. So we have some employees that are federal employment, they're state employees working in the federal program as our employees. And then we also have contracts in the state with federal government to do different work. And so there's two different components. We have our employees and we also have the contracting. And if the federal government comes out and takes the approach on the federal drug testing around cannabis use, how is that going to impact our opportunity to execute the contracts, maintain compliance with the contracts, and also maintain employment if we have different employment standards for state workers versus federal workers? And so I think that was something that we want to keep our eye on as it unfolds. And I don't think that's a big highlight of the discussion draft, but it certainly caught our eye. Some of the other concerns are using terms like inadvertent as it relates to delivery of hemp. That kind of is a challenge because that really creates a different standard of knowledge base when you're going through on the delivery area issues. It also calls out a 10-pound limit, and we're wondering, on a possession limits on 10 pounds, is this flower only? Is this all concentrates and edibles? And it's really generic in terms of limitations, which obviously far exceed our current limitations in our state. But we'd like to see some clarity around that. Under the research, training, and prevention areas, there seems to be data points that will be difficult to capture and review. And they talk about having comptroller reporting and those types of things. But when we're looking at issues as such as high school dropout rates correlating with cannabis use, sick leave usage, and those types of things, this could be a challenge, especially as employers may be at risk for seeking excessive medical information. And so how are those data points going to be captured? Is that going to be incumbent upon the state to collect and provide federally, or are the feds going to do that on their own? So we thought that was worth calling out. And then this should include impacts around the polydrug use on impaired driving, not just cannabis impaired driving. And that would be a real positive to make sure that we correlate those types of things. So the gathering data would definitely be beneficial for assessments on the long-term impacts of legalization, but we definitely want some uniformity in those particular areas as we've seen within our state. On the packaging and labeling front, we also have, it appears to be a little bit more restrictive, impacting Washington to ensure the federal approval. It would have to add additional steps to our processes. It's going to slow our approval times down. And we've seen the approval sometimes within the federal government take a little bit longer. So it could really stifle some of the business interaction and correlation on the marketplace. Descheduling from Schedule 1 could certainly change the post-prohibition approach. So what I mean by this is, as we went from post-prohibition in alcohol and cannabis both, it is still generally illegal, except for if you have licenses, except for when these different provisions that are called out in law. So that's what I mean by the post-prohibition approach. If you deschedule it and just say, okay, it's no longer a Schedule 1 drug, does that change a lot of the laws across the our state as well as the United States on calling out the exceptions? Do we change from the exception-based approach to a prohibition-based approach that you can't do these things instead of you can't do everything except for these things? So I think it could throw a different structure and dynamic in the states that have those types of regulatory structures. And then the last thing that I wanted to call out is when we're looking at the legal implications across the United States with alcohol, one of the things that we believe Congress should specify whether or not states may maintain the residency requirements for cannabis licensing. And that would certainly help avoid any unnecessary litigation that evolves, because we see the litigation on the liquor side around residency requirements. If they could be clear federally what that means, then states could adopt that a little bit more appropriately and avoid that type of litigation. So those are kind of the highlights. And as we're looking at this, the next steps on this is, we're going to continue to work in our small groups within the agency to try to figure out what we want to highlight for a potential response. we definitely have to start working and coordinating with the governor's office to make sure that they're comfortable with the information that we would propose to share. We may even want to work with our liaisons in Washington, D.C. to make sure that we have those types of things. So I think that, we have a number of steps to do before we're ready to send anything, but we certainly want to make sure that all of this is vetted with you three prior to moving forward. And so this is an earlier step, just trying to get through the discussion draft, pretty much debrief on this, and figure out where we want to go to what we want to present to our congressional delegation, essentially. So with that, I'll stop there and offer an opportunity for questions here.
Thanks. Super impressive work you all have been doing on it. Member Huggy, questions?
Yeah, Justin, is there anything in the draft that specifically addresses the issues related to the Commerce Clause and interstate restrictions or the potential for restriction on interstate commerce? That's something that, I don't know, probably as a result of a bad experience in law school, I've been thinking about a lot. Because it is the linchpin for basically harmonizing, in the good sense, restrictions across the country for different substances and different practices. Is that called out in this draft?
So I don't think they heavily go into the Commerce Clause dynamics. They do have areas that weave into that discussion. So as they're calling out the interstate commerce issues, I don't think that they've necessarily set out a lot of clear language that is going to create the foundational piece for a lot of those Commerce Clause challenges that we've seen in the past. However, they are specifying, states are going to have the rights to govern and regulate cannabis. And if you are a state that chooses not to do that, you still have legal opportunity to transport through those states. And so, in regards to, the interstate commerce opportunities, there is some language creating opportunities that states can't necessarily go and take action if you're transporting it through that state. That still, to me, created a little bit of confusion on how that would be applied if it's just the interstate freeway systems and those types of things, or what happens if it deviates into other areas of a state and then they get contacted by that state. I'm not sure how that's going to play out, but as far as the Commerce Clause in general, there are some provisions around trying to protect the commerce from happening, but I don't think that they really laid out a lot of pieces that would prevent some of the previous litigation that we've seen at this point.
Member Garrett, do you have questions?
No, as I was writing down my notes of questions, the more Justin spoke, the more he covered some of it. And then even the piece about, are we participating and able to share, and are they reaching out to the legalized states as they put this together? But this is just the first draft, right?
Yes.
Okay, so this has a long ways to go. So some of the questions I was going to bring up with, because it said on the social equity page 44, because I think it would be really great if the task force keep an eye on this to see how we are working alongside this as we're putting our recommendations together. But being a first draft, it's probably going to be kind of difficult trying to see what their definition of social equity is compared to what we're coming up with, because anything can change at this point.
Yeah, and what I'd offer also, because I don't have all the details around this, but I know we've had some conversations with some of the federal agencies. Now, nothing's established yet with federal agencies on who's going to be, tasked with which responsibility. But as we've had some more informal discussions and call out these issues, they were like, yeah, that needs to be raised because that's not what the intent is here. So we want to make sure that when we see these things that we can raise them appropriately so they can consider it as the drafts develop over time. I think nationally the consensus is, there's going to be a number of iterations of drafts that are going to come out before the end. So as a first draft, it gives some food for thought. Let's put some ideas on the table to say we would request that the federal government consider these provisions so that it doesn't negatively impact states and programs that are already in place.
On the committee or group in DC that's working on this draft, do we have representation from Washington State that's part of that?
Not necessarily on the draft. I'm sure that the congressional members are a part of that, so I don't want to misspeak in that. But as far as having a specific delegate from our agency or something like that, we don't. No,
I'm just saying one of the congressional. Yeah, I'm not saying our agency.
Senator Murray is chair of health, education, labor, pension, I think it's called, where the bill's going to be worked at least at some level. And her staff has reached out to us and we've to them. We've already had a couple of conversations and will continue to. So Senator Murray seems to definitely be able to play a role. And I expect on the Senate side where this is starting, Senator Cantwell is well from her committee. So yes, I think that they know of our interest.
Okay, and are they aware of the Social Equity Task Force?
Well, I don't know exactly to the extent of that, but that's part of what we all need to do now. And I think this goes back to what Member Hauge was talking about. How do we respond and position ourselves facing the prospect of national legalization, decriminalization, whatever that ends up being. So these are things I think that we need to talk about is how we're going to approach those. And it's a conversation for the board as well on our own, but I think we want to engage with staff as Mr. Nordhorn's work continues with these small groups in the agencies. Maybe the three of us need to split up as well and be a part of those. And because you're on that social equity task force, you should be in that. And Member Hauge, it's all under the legal rubric, so you can take your pick. But just so we're being sure the three of us or no two of us show up at the same meeting, I just think it would be good for us to the three of us to be able to pick pieces of this to really get up to speed on. And I'll say, I don't think it's going to happen anytime soon. I just don't. As soon as this came out, within 24 hours, the sponsors themselves were, downplaying the prospect of any action, and it just is not imminent in my layman's view. But it behooves us to look at it because it will happen at some point. To the comment about looking for the feds to create a floor, which is how a lot of federal regulation works, and the states can be more stringent. The problem as we go through this, though, is that sort of dynamic changes depending on what issue we're talking about. So criminal background checks. They may set what they consider a floor for which violations. And we kind of would go in a way that they might see as less stringent, not more stringent. So, what we need is flexibility. We need states' rights on this. The states are the pioneers on this, and I am hopeful and somewhat optimistic that they will listen to the states because we've been out there doing this where the federal government has experience in nothing related to this other than shutting it down. More thoughts from the board? Okay. Thank you for that, and we will follow up and figure out how to triage ourselves and become more a part of those conversations at staff level, and then also the board wants to start looking at what do we want to do in anticipation of this, not necessarily any specific provision of a bill, because to Member Garrett's point, who knows what that'll look like when it happens. But if we expect there will be legalization or decriminalization or normalization at some point in our tenure here, it would behoove us to start looking at what are those things. So I think we will find a way to keep engaging with you and your group on that.
Thank you.
Great. Thank you. Appreciate it a lot.
Absolutely.
Okay, let me find my agenda here and we will move to the next. And oh, I see Kathy Hoffman, so now I know what we're doing next. Thank you. We're going to move into board meeting prep for tomorrow's meeting and a rules update, and I will turn it over to Kathy Hoffman, the Policy and Rules Manager. Hello.
Good morning, and thanks, Chair Postman. Good morning, Board Member Garrett and Hauge. I'll give a quick update on what I'll be presenting at the board meeting tomorrow, and then a quick update on the THC compound evaluation work that we're doing, and then I'll hand it over to Jeff, and then to Audrey to follow up. So in keeping with our kind of board interim policy cleanup project, as it were, I'll be bringing 5 board interim policies to you tomorrow for rescission. Hope you had an opportunity to look at those. So I'm not going to spend a lot of time going through them today, but suffice it to say, 4 of them are ready for rescission because they've been implemented in policy, in rule already. So I won't go through each one of those individually today. We are recommending that we rescind a policy that was issued in the year 2000 that, according to some of our staff, hasn't been used in 18 years. So we think that it might be appropriate to rescind that policy at this time as well. And in fact, it isn't even called a board interim policy. It's called a liquor control policy. So sort of a historical piece of LCB work there that we're recommending for rescission tomorrow. So any questions on that before I move forward with?
None for me, and I don't see any others, so thanks. So,
all right.
Okay, no, we're good.
All right. Thank you. And then just a quick update on the THC compound evaluation work. Our 102 package is in the process of internal review completion, and then I will share that package with the board this week and our executive leadership, and then we'll be ready to present that to you on October 13th. At this point, we're not sure if we're going to have a board meeting on the 24th, it's the day before Thanksgiving. So that would push our 102 hearing out to December 8th. However, that does make it possible still for us to have rules adopted either right after the first of the year or shortly thereafter. So we're not diverging too far from our timeline on that particular project. So just wanted to give a brief update on that.
Okay.
Questions on that?
No, but we'll have to figure out schedule of the board meeting. I'll be traveling that day, I believe, but may be able to participate remotely.
Yeah, just a detail need to work out before the 13th of next month.
Yeah. Okay.
All right. Well, with that, any questions, Board Member Hauge? No. Okay. All right. With that, I will hand it over to Jeff. Thank you.
Thank you. Good morning.
Good morning, Chair Postman and board members Garrett and Hauge. Here is a brief update on cannabis rules in progress today, September 28th, 2021. Regarding the Cannabis Quality Control Rule project, we continue to work with the economists from Industrial Economics Incorporated, or IEC. We have now completed 6 scheduled weekly meetings with IEC. As part of that work, we sent an invitation via GovDelivery on August 30th seeking interview participants to help us understand cannabis producer and processor perspectives. We received approximately 35 applicants in total, and we stopped accepting new interview applications on September 10th. As of yesterday, IEC had held 18 interviews with producers and processors and is working to schedule another 7 interviews. And also last week, we held an online multiple choice survey to help us understand producer and processor perspectives beyond the deliberative dialogues we held earlier this year. The survey was open for 1 week and had 116 responses in total. For the cannabis quality control rules, we now anticipate hosting a listen and learn session on or about October 21st, putting our CR 102 proposal at approximately December 8th, 2021. And this concludes my update for today. And may I answer any questions?
I don't see any today. Thanks, Mr. Kildall.
Okay, thank you.
And then I think, yes, Audrey Vasek. Good morning.
Good morning, Chair Postman, board members Garrett and Hauge. So I have a couple updates on the alcohol rulemaking timelines today. First, for the rule project to implement 2021 legislation, House Bill 1480, related to extending COVID-19 allowances, I'll be presenting the CR 102 package and proposed rules for your consideration at tomorrow's board meeting. So just for some background, to prepare the CR 102 package and proposed rules, the internal LCB rule drafting group considered all the public comments we received via email and during the 2 listen and learn sessions held on August 5th and September 2nd. Each of those were attended by over 50 people. The public comments from those sessions and other public comments we received via email are included in tables attached to the CR 102 memo. And the memo also describes how that stakeholder feedback was incorporated into the proposed rules. The policy and rules team, Robert and myself, also interviewed 12 volunteer licensees between September 15th and the 21st, so over a week, to gather data on estimated costs of compliance in order to meet Regulatory Fairness Act requirements. This cost of compliance information is captured in the CR 102 form. Just as a summary of the proposed rules create new temporary endorsements for the to-go sales of cocktails and wine by the glass, manufacturer sealed alcohol products, and growlers. The proposed rules also create a temporary new rule section that provides licensees with more options for outdoor alcohol service areas and permanently amend existing food service menu requirements to provide more flexibility for licensees. If the CR 102 package is approved by the board tomorrow on September 29th, I will file the CR 102 and proposed rules with the Code Revisor's office. The formal public comment period will open and the public hearing will be set for November 10th. After that public hearing on November 10th, the formal public comment period will close, and if no substantive changes need to be made to the proposed rules, as a tentative timeline, the CR 103 or final rules could be filed on November 24th at the earliest. If the CR 103 is filed on the 24th, the rules would go into effect 31 days later on the 25th. So the tentative timeline would have the rules complete by the end of the year. Happy to answer any questions on this before I go into my next brief update, if there are any.
Seeing none? Nope. Let's
Okay.
move to the next. Thank you.
So for the rulemaking project related to axe throwing at liquor license premises, I'll be presenting the CR 101 package, also known as the pre-proposal statement of inquiry, to begin rulemaking on this topic at tomorrow's board meeting. So if the CR 101 package is approved by the board tomorrow, the public comment period will remain open until November 19th. And in terms of a tentative timeline for the project, before a CR 102 or rule proposal is prepared, we'll engage in collaborative rulemaking to gather feedback and ideas from stakeholders and any interested members of the public. This will likely include 1 or more listen and learn sessions, and the feedback we gather during that process will help guide the internal rule drafting group as we develop rule language. At the earliest, I anticipate a CR 102 or rule proposal could be ready for the board to consider in January of 2022, which would place finalization of the rules in April of 2022 at the earliest. So I'll get into more background on that project at the board meeting tomorrow, but I know you've heard that before, so wanted to keep it brief today, but happy to answer any questions.
I just had one on this, which we had talked about before, but I don't remember the answer, I'm afraid. We have essentially a pilot program going on right now for one licensee to be able to do this. And there will be a report after that. When is that? When does that pilot program, in essence, end, and when might we have an assessment of how that worked?
So it was a 1-year pilot, and through that settlement agreement, and that which was approved in April. So my understanding is that 1-year period would end April 2022, and at that time they'll have to submit the data required in the settlement.
And David, I asked Audrey some similar questions of so far what has happened and what's any feedback, and she answered the questions. If you wanted to cover that, Audrey, the 2 questions. Enforcement has been out already. I was looking for the email, but you might have it handy.
Yeah, Member Garrett, let me, I can speak to those. So I reached out to the licensing division and the enforcement and education division to follow up on your questions. And the enforcement and education indicated they'd sent out, for the initial new licensee briefing in May of 2021, someone to go check in with them. And, nothing really new to update there, other than they just had a check-in with that licensee, and there's no data really at this point other than that licensing has gathered, but they would expect to have that data at the 1-year mark for the pilot, and if there were no incidents at that point, they could consider extending, or if the rules are in place, then just go with that. But so hopefully that answers it. Does that answer your questions, Chair Postman and Member Garrett?
It helps. Yeah, and on that settlement one, if at the end of the year, just for the sake of this conversation, there is no record of problems there, does that settlement agreement then allow for open-ended continuation of that program? And again, would it just be at that one facility, absent rulemaking?
And all of that was in that email you sent me, Audrey, that I was saying if you can speak on, because you answered those questions for me. Well, I had the same questions, David.
Okay. If you can send it to me anytime, that would be great. And I'll look at it before our meeting tomorrow. We don't need,
I'll make sure to forward that to you. Great. And if there's any follow-up, I can reach out again and get you those answers.
That's great. Okay. Any other questions on this? No. Okay, great. Thank you. I believe that is the end of our rules updates. Next on our agenda is agency-wide updates from Director Rick Garza.
Good morning, board members and staff. I wanted to just go back to Justin's presentation today. Thank him, thank the staff. So you're aware there were 3 or 4 different sessions that were held to look at the draft proposal that Booker, Wyden, and Schumer have introduced. And so staff really did walk through that pretty deliberately. We'll do that again to kind of finalize that document, just so you know the actions, because all of you had asked specifically about how is that interaction occurring with our congressional delegation. So I think we reached out to them, I want to say about a month and a half ago, all of the congressional delegation, because of a meeting that we had held with CANRA to introduce our congressional delegations from throughout all the states to be part of a discussion that we had. And we'll vet that response with you again once we've had an opportunity to go through it. We'll sit down with Sherry Sawyer in the Gov's office to make sure they're comfortable with the response. We'll send that response to our congressional delegation. And as David had shared, we had a meeting with Senator Murray's staff. But once that's done, then we'll provide that response to a congressional delegation. And then I'll work with Chris Thompson, our legislative director, to get a meeting together with the congressional delegation. And typically that's always going to be staff, to kind of walk through that response that we created. And then that kind of gets us done with the work that we need to do with our own congressional delegation. And like you all said, this is years away. But certainly we need to be involved step by step, just as CANRA is. Just so you're aware, in December, it's likely that members of the CANRA Executive Committee will be setting up a meeting with Schumer, Wyden, and Booker to just do a meet and greet with us. New Jersey, New York, Oregon, the states that these senators are from, are members of CANRA. And so the idea is to begin to establish that relationship. And our directors in those states have already had discussions with their US senators that are on that proposal, but a wider discussion to begin probably in December. And then David had mentioned that CANRA has been in several meetings with the federal agencies, FDA, TTB, just recently met again with TTB, and TTB, Tobacco Tax Bureau, is the agency that likely would permit or license cannabis licensees throughout the country, just like they do for alcohol. So that's kind of a similar agency that would do that work. And the issue came up that Justin spoke about, the concern that if TTB is issuing a permit or license and they're doing a criminal history background, that might interfere with our social equity program. So when I was on the phone last week with TTB and members of the executive committee with TTB, I shared that, and they were they had not thought that through, is what I got from the discussion, but were very concerned that they not do anything that would interfere with the ability of the states to allow for social equity applicants, and the fact that we're going to be looking at criminal history differently in the future with our social equity applicants than we did in the past when we started the program. So TTB was notified, and they immediately said, yeah, we've got to take a look at that. And so part of this work that we're doing, not just in the state with our agency and our congressional delegation, I just share with you that there's a lot of commonality. CANRA released a letter to those 3 US senators on Thursday, and I hope that we sent you a copy of that. But the first 2 pages are just a cover letter identifying 5 areas, many of the same ones that Justin identified. And then you've got 5 pages of details within those 5 topics of specifically what we're asking that proposal, what our comments are to that proposal. And it's more about the nuts and bolts. It's not about whether we support legalization or not. It's really about the nuts and bolts. And Justin spoke to them, like packaging and labeling. How are we going to share that responsibility with the federal government? Right now, they do packaging and labeling for alcohol, TTB, for manufacturers. And so there is some history there, but it's not the same. It's not the same at all in the complexity that we have, for instance, in packaging and labeling, because of the different ways you can ingest and consume cannabis. And so that's just an example that I wanted to share with you. But I just wanted to thank Justin and the staff for their work on that, and just wanted to share a little bit about how I see that moving forward. FYI, last week, Congressman Perlmutter from Colorado, who worked with our own Congressman Denny Heck on the Safe Banking Act for the last, I want to say, 5 years. It's passed the House 5 times, but has never gotten a hearing in the Senate. But that was there was an amendment, the Safe Banking Act, that was placed on the Defense Authorization Act, which is a spending bill, and it actually the amendment was approved on a voice vote. So that's something moving forward that's positive. When you talk to the U.S. senators that have introduced the bill that we just spoke of, they don't want to take that isolated look at just safe banking. They want to see comprehensive reform before they allow something that seems obvious to be approved. But it just gives you an idea that federally what they're looking at is they want all the pieces together, including social equity, the reinvestment fund, and just creating interstate commerce, as Russ was talking about. I think Justin spoke to it, but to your point, Russ, they want to be able to have safe haven when they transfer product. So they're looking at possibly a national traceability system similar to what we have in the state, where you would be able to manifest and track cannabis that's moving through the states. But as Justin said, I think there's a provision in it that creates kind of a safe haven for those states that have not legalized cannabis to be able to transport cannabis through that state. And so I won't get into any more because I have so much more to cover with you. But I just, again, I think we're moving in the right direction in how we're going to respond to that. And we'll have time to go through that with you. Yesterday, our staff, Justin, Kathy, Chris, Bruce, and then Julie from communications did a webinar for an hour and a half on the cannabinoid bill that we have. And I thought it went really well if you were able to listen in on that. It is recorded, so you can go back and listen to it. But I think some of the comments and the questions we got in the latter half showed that people are certainly have questions around it. But I think they appreciated the work that the staff did to really bear down, specifically to the specifics of what the intent and purpose of that bill is. And so we'll I think Justin had said this morning, we'll put a meeting together with a small group that worked on that and figure out where we want to go with some of the input that we got, and then obviously come back to the board to make sure you're comfortable with where we end up with that bill. Thirdly, the enforcement had their in-training conference last week in Chelan, had a great turnout. It was a really good meeting. Tony and I and folks from licensing and from HR were there. Went very well. David, as stated earlier, you did a video that was appreciated by our enforcement division. Gordon Graham, if you're aware of him, does consulting on risk management, and he was the first day and it was very good. And I've heard Graham before. The principles are all the same, but the stories are a little bit different. But it was I thought a really good way to open their conference. Secondly, we have, thank you, Ollie, for helping us in the interview process for our DEI manager. We have selected a person, and you're aware of that. And in this day or tomorrow, we'll announce who that person is. And I just want to thank Ollie and the staff that helped us through that long interview process. We've also began the interview process for Sarah's position, the Public Health and Education Liaison. We'll be doing a second round in the next week. And so we're close to making a decision there. Just wanted to share that with you. Last Friday, I was on a panel with Representative Kloba, who's chair of the House Commerce and Gaming Committee, Sherry Sawyer, the governor's senior policy advisor, and then Michael Corella, who is, I think he's a lobbyist for NCI, which is the National Cannabis Industry Association. It's been around for about 11 years, but it represents it's a trade organization that represents multi-state licensees across the country. And the topic and the issue was preparing for federalization. And so we all talked a little bit about what are some of the changes that need to occur in the state to prepare for that. And then more importantly, Michael and others talked about the strategy or the lobbying that will occur on that bill and the work that they've been doing. And we thought it was about an hour and 15 minutes, but it was a good panel to be on. A lot of good questions, and I know that David and other staff were at the Cannabis Alliance annual meeting, I think the day before. And so we were well represented as far as the LCB in that meeting. I'm doing a cannabis law podcast with Bruce Turcott, our assistant AG, tomorrow. There's a group of state AGs called the Cannabis Alliance, and they're the AAGs that work in all the legal states that formed about the same time that CANRA did. And they have podcasts and webinars that they do for the lawyers around the country. And Bruce and I have been asked to do a podcast with them tomorrow. As you know, we've been in the process. The governor mandated that by October 18th, all of our state employees must be fully vaccinated. Obviously, there's a religious or medical exemptions that we're working through with some of our employees who have asked for that. If they do meet the exemption, then we have to find out whether we can provide them with an accommodation, which is difficult for some of the positions that we have, as you know, in our agency. But just so you're aware, out of our 341 head count that we have in our agency, 253 have been verified as fully vaccinated. That's 17.43%. And hopefully in the next couple of weeks, we'll see that significantly increase. But just wanted to let you know that, like all the state government, we're working through that issue with our own employees. And so with that, Mr. Chairman and Board, if you have any questions for me, I'm available.
Okay. Questions for the director? Not seeing any. Rick, just two quick things from me. One, can you have somebody forward me the resume of the DEI manager selection? I'd be interested to see that. And the attaching that banking bill was an interesting strategy, but I'll bet the store that does not survive the process, since the sponsors, as you mentioned, of the legalization bill think it would be a bad thing to liberalize the banking laws before decriminalization. And so the House just keeps trying, but I can't see that that's going to survive the process. But and then on
just to prove how small the world it is, Mr. Chairman, guess who chairs the Armed Services Committee?
It's Adam Smith. Yeah.
Who allowed the amendment.
Yeah.
Even though some people, like you say, thought it was outside the scope of the defense bill.
Yeah.
Yeah.
Yeah. Well, that's good. He's taking care of his constituents too.
Yeah.
I mean, we're all for it. I just, we got to be realistic, and that is one of the easy things that would happen, I think, with a national bill. You couldn't do that national bill without liberalizing the bank laws. So thanks for that. Okay, I think that's it. Thank you, Rick. Appreciate that. And it brings us to our last item, which is executive assistant and board member reports. Dustin, anything to share today?
Nothing for the good of the order. No, thank you.
Great, thank you. Member Hauge, anything to share?
Well, I feel like I should give you a report on what I did over my vacation. I did not travel to visit family. I went from detection to diagnosis to excision of a cancerous tumor in the last 3 weeks. Prognosis is just fine. Follow-up is still being determined, but I'm not in any danger. It's a bladder cancer, which is treatable and has been treated. But I wish I would have been able to go see my kids instead of doing this. Anyway, with your permission, I will skip the litigation review this afternoon. But I will be on board for the board meeting tomorrow, and we'll be getting back into the swing of things here, starting from this point on. I really appreciate the support I've gotten. Dustin has been outstanding in keeping in touch with me, and
Great.
I appreciate the report here, the work that Justin Nordhorn has done. What we're doing is outstanding, and I appreciate the support you all have given me. Thank you.
Absolutely. Thank you. And I'm confident it doesn't violate the Open Publics Meeting Act that we've all been sending you our good thoughts. So we'll just go ahead and put that on the record. So thank you, and let us know if there's anything more we can do. Member Garrett, anything to share today?
No, nothing to share.
Okay, great. And with that, we will adjourn the board caucus meeting for September 28th. We'll see you tomorrow for the board meeting. Have a great afternoon.
Thank you.